You are listening to the Marc Guzman Podcast Experience. California marijuana legalization. So what does the initiative allow? On November 8th, 2016, the voters passed California's Prop 64, Control, Regulate, and Tax Adult Use of Marijuana Act, which legalized recreational use of marijuana. This legalizes the recreational use of marijuana for adults 21 years or older. Smoking and other uses are permitted in a private home or at a business license for on-site marijuana consumption. An individual is permitted to grow up to 6 plants within a private home as long as the area is locked and not visible from a public place. So how does this apply with smoking policies in federal law? Well, smoking is still prohibited in any place where tobacco smoking is prohibited by law, prohibited in any public place, and cannot possess on school grounds, youth centers, or daycare centers when children are present. If there is a local ordinance that prohibits tobacco smoking on residential properties, such as Richmond's no smoking in a multi-unit building ordinance, then smoking of marijuana is also prohibited. Marijuana is still illegal under federal law, and while marijuana enforcement was not a priority under the Obama administration, if you complied with state and local law, the Trump administration may make it a priority. The initiative expressly allows owners of rental property to prohibit any of the actions related to marijuana. Make sure to have a no smoking clause in your lease agreements or have an addendum that includes all substances, including tobacco and marijuana. Now, what if a landlord wants to allow recreational use or cultivation? If you want to allow recreational use or cultivation, that is your choice. However, consult with an attorney to develop policies to protect your investment or quiet enjoyment of your other tenants if it is within a multi-unit building. Now, what if the tenant is disabled and wants to use marijuana as a reasonable accommodation for disability, aka medicinal usage? Now, here's a disclosure. If you get a request like this, contact an experienced attorney right away to determine an appropriate and timely response. But the initiatives are not clear on this issue. Now, there are 2 court cases that suggest that an accommodation that requires an owner to allow a violation of federal law is not reasonable. And the same would apply to a tenant receiving Section 8 housing assistance because the funds are tied to HUD, which is a federal program. So it seems as if you can deny it because you would be violating federal law. However, my suggestion is you do not want to be the case study when it comes down to that type of situation. So make sure to look at everything on a case-by-case basis. Be reasonable as a landlord. Cooperate in a way to where you can negotiate something with the tenants. Usually if it's just a single family house, condo, townhouse where it's just you and the tenant, just one unit, it can be worked out. But when it in a multi-unit building, it becomes a lot more difficult because you have to really take into account the quiet enjoyment for the other tenants within the multi-building. Again, contact an experienced attorney to help you out navigating through any issues when it comes down to a reasonable accommodation for disability and medicinal use. Thank you so much for listening to the podcast. Thank you to our producer, Sam Lubman. Please subscribe, like, comment, and share the podcast. Remember, you can listen to the podcast on iTunes, Podbean, iHeartRadio, Google Play, SoundCloud, and anywhere else you listen to podcasts. For more information on my business as a property manager and real estate team, go visit my website at marcguzman.com.